All right. Hey, everybody. Welcome to another episode of The Compliance Guy. I'm Sean Weiss. As always, I want to start off by saying thank you all so much for tuning in, logging on, and just hanging out with me for a little while as I get to spend some time with my good friends. And today, we have a really interesting conversation, and I'm hoping that we're going to be joined in just a little while by Ron Chapman. May or may not join us today. We'll see what happens. But in the meantime, we have two phenomenal guests. The first is Colin Callahan. Colin is a former prosecutor. He's come to the rebellion side now, and he is based out of Pittsburgh. Colin's been on the program before. We'll talk a little bit more about his firm in just a little while. And the other guy joining me today needs no formal introduction, but I will say he is my brother from another mother, retired. I almost said former. I don't know why I keep almost saying former, because that insinuates bad things for Eric, at least in his mind. But retired OIG Special Agent Eric Rubenstein. Guys, as always, thanks for carving some time out of your busy schedule to hang out with me and to share your knowledge with our followers, our viewers. Welcome to the program. Colin, how are you? Eric, how are you?
Doing well. Happy to get to chat a little bit again.
I'm still good.
Eric, I was going to say Eric's neither happy nor disappointed to be here. So today we're going to spend some time today talking about private equity. And I think this is such a critical area right now for a lot of reasons, because we all know healthcare is a lucrative industry with a lot of opportunity to hit it big. But it's also a snake pit waiting for its next unsuspecting victim to fall in. And for decades, physician owners, have found themselves in a perpetual cycle of on again, off again when it comes to the business of medicine. So enter private equity and what many have termed unicorns. But when they term it a unicorn, they wind up finding out that in a lot of cases, it's actually the devil's horns and not an alicorn. So I want to be clear that it would be extremely easy for Colin, for Eric, and I to sit here and villainize those in the PE space. But the fact is, it would be unfair since we have all worked with PE firms over the years to ensure that their entrance into a healthcare organization, along with the transition that is often required for things to run like a well-oiled machine, were being done in an ethical, compliant, and legal way. But again, not all PEs are created equal, and not all have the same good intentions. And that's where things can go from bad to worse for physicians giving up a piece of or the entire pie. We all know that healthcare is a juggernaut in so many different ways, from the structure of payer reimbursements to legal ramifications for engaging in acts that other industries don't give a second thought to. And what I want to explore with Eric and Colin today are really the risks associated with PE coming into the space and not doing their due diligence, but also providers not doing their diligence before climbing into bed with a stranger. So we're going to talk about the legal aspects, and then we're going to talk about some of the law enforcement. And if that sounds good to you, I want to start with you first, Colin, if we can. Let's talk about the legal ramifications for engaging in what the government oftentimes refers to as schemes or artifices that PEs could find themselves a part of.
Sure. Yeah. And I think the way I always think about this, Sean, and I don't know if this is how you think about it as well, I mean, if you're dealing with private equity, the PE firms are potentially buying the full panoply of, issues du jour that are out there at any given point from a fraud perspective. But there's a couple of them that I think are they're even more susceptible to than some of the others, right? And so, on the criminal side of things, you're looking at potential healthcare fraud charges related to whatever a particular industry, might be facing. AKS charges are always going to be, a significant potential component, where you do have private equity money coming in. I think in part because the entire idea of AKS, anti-kickback statute, is so alien to, investors and frankly business people that aren't familiar with healthcare, because incentivizing people to send you business is sort of a core concept in really every conceivable component of industry other than healthcare, right? So I think, you see that one in particular where people stub their toe and have problems, whether that turns into a criminal case or a civil case. And then, another area that I think we've seen a ton where it can be criminal or civil, would relate broadly, I would say, to sort of staffing levels, right? Because private equity is always, from a business model perspective, focused on the idea of what they would would deem a positive, which is efficiency. So how do we find ways to provide care in whatever nook or corner of the, healthcare space that we happen to be talking about here, in the most efficient manner possible? How do we find a way to do this and still provide quality care with 3 people rather than 5, right? Which can be good and can, bring innovation to the sector if done properly, but which also can run afoul of, relevant state, federal laws on staffing levels, can get you into trouble in terms of, criminal or civil charges. And then I think there's even bigger exposure, on the False Claims Act side for private equity, is where I would sort of say that the biggest problems potentially lie. And there, I'd say over the last 10 years, as we've seen private equity money continue to explode in the healthcare space, but not necessarily having the knowledge base explode with it, in terms of who's sitting on the PE desk for the acquisition, you may be buying huge problems that you haven't done due diligence on the private equity side, and then you're not correcting problems that then lead to treble damage exposure from a False Claims Act perspective, and $20,000+ per claim liability, as a result of policies that you didn't necessarily even set up in the first instance, but which continue on your watch, and where some of the recent case law from a False Claims Act perspective says, well, if you should have known, that's good enough to potentially reach you, for all those penalties that we just talked about.
So I think that's such a great point. And you made a lot of salient great points in that. And I want to break down 2 of them. So obviously when PE companies and or their managers originate or perpetuate growth in healthcare or highly regulated companies, right? Or if they're receiving credit for growing revenues or values through non-compliant conduct, these activities create liability under the False Claims Act. Mm-hmm. And specifically, you're talking, because you talked about the treble damages, right? So you're talking about 31 USC subsections 3729 through 3733, right? And what it says is specifically that any person who knowingly submits or causes false claims to be submitted to the government or makes a false record or statement to get a claim paid by the government is liable for up to triple the amount that the government's actual damages are, plus a penalty for each and every single claim, which ranges, I think now in 2022, anywhere from $11,665 up to $23,331. But the other thing that you brought up, and we'll go back to exploring the False Claims Act in just a minute. The other thing that you brought up was the anti-kickback statutes, right? Mm-hmm. So, Eric, as we've talked about in the past, really, AKS cases, are not really something that, manifests on its own, right? These are usually because somebody told on somebody, right? That's how these anti-kickback statutes, or somebody documents something stupid, like they put, the name of a physician in the memo on a check or something like that, right? But tied to the anti-kickback statutes is another little unknown law, which is ECRA, and it's becoming more and more prevalent today, right? ECRA was passed in 2018 as part of a nonpartisan bill with Amy Klobuchar out of Minnesota and Marco Rubio out of Florida. And ECRA has a much more narrow focus on safe harbors. I think there's only 7, as opposed to there's 11 with 32 subparts or something like that under the AKS. But Eric, the anti-kickback statutes, because you were an agent, how were you all finding some of these violations that existed between PE firms and physicians?
Yeah, so it's a good point. So so just to go to ECRA for a second, the big challenge in ECRA is that for a long time, because it's only been a few years, but relatively speaking, prosecutors were really not interested in looking to do cases that involve ECRA, because there was this belief that it was a little bit broad and overreaching with respect to labs and that kind of thing. The whole point of ECRA was really to address kickbacks in the illicit relationships between sober homes and labs with things like UDT or urine drug testing. But if you actually read ECRA, it actually includes essentially any relationship between the referring provider and the lab who's doing those services. And so there may be some legitimate things that are out there that would have fallen under a designated health service, and then been maybe a carve out under Stark, but now falls under ECRA. And so, that's the issue. But getting sort of to your question, Sean, is, the thing about these cases, and, I'll talk about PE or private equity in a much broader sense. And, when you're talking about things like the corporate practice of medicine, a lot of the cases, and you're right, typically a kickback case comes as the result of someone telling on themselves. And so you've got to, have someone who's a cooperating witness, because in the kickback case, and Colin, as a federal prosecutor, will probably agree with this, that you can have all of these kind of factoids that surround it, but unless you've got somebody to get on the stand and provide sort of color for a jury to explain that this was an illicit relationship, okay, we have this document that's a management services agreement, or it's a thought leader or something like that, that unless you've got someone who can tie in how these calculations existed, it's sort of difficult to do it in a vacuum. But you got to think about private equity in a couple of ways. One, there's the large hedge funds that come in, and these organizations that come in and dump millions of dollars into a business that they're looking to grow and expand and build on. And that's all good and well. A lot of these cases wind up being the creation of a sham management services organization, or, really in the corporate practice of medicine world, you have a company that comes in, they create a parallel LLC, and that parallel LLC becomes the management company for the practice. But really, it's no more than the colloquial term is the doc in the box, where it's a doctor who is the owner of the PC, and on paper it looks like they're operating the business and they're in charge, but they're really not. They're a puppet to ultimately what the LLC is that's running it. So you can discover these things if you're trying to do this legitimately. You can discover these through due diligence. Like, why is it that the practice brings in $1 million and $999,999 are pulled out for management fees and the costs of operating the business, which, at the end of the day, the only thing that the management company is not responsible for paying for are the professional services of the organization. So, why is it that there's no money left in at the end of the day? So, some bank records are going to show those kinds of things. There's going to be cooperating witnesses on these kinds of things to show that there is this kind of circumvention of the corporate practice of medicine rules.
So, Colin, I want to go back to you for just a minute here because Eric brought up a really interesting point about management service organizations. And as a former prosecutor, I know that the DOJ for years has heavily scrutinized MSOs for a lot of the reasons that Eric was starting to address. And I came from, two of the largest US based healthcare organizations back in the 90s, where both of them had MSOs. And I'm not going to get into talking about what did or didn't happen at those, but from a former prosecutor's perspective, um, when you were looking at making, using prosecutorial discretion and making a decision as to whether or not you were going to pursue litigation against, an organization that was functioning as an MSO, what were some of the things that you were looking at specifically that gave you that aha moment to say, gotcha?
Yeah, I think it's a good question, and of course, the details are really where all of that stuff is gonna where the rubber's gonna meet the road. So I would put off to the side sort of the small one-off, comparatively small one-off sort of setups that oftentimes are the cases that may result in, let's say, criminal AKS sort of problems or the like, right? Because those tend to be, you can call them private equity, but those tend to be, sort of folks that are investing, some handful of millions of dollars to functionally create a sham agreement that they then profit from. And so, I don't think there's generally going to be really good arguments as to the legality of those kind of organizations and arrangements. Those are kind of the easy cases, I think, if you become aware of them. Where typically, there's going to be a variety of problems. I think the more interesting cases are where you have this kind of a structure, and we see this a ton now in the dental world, for example, right? That's been a sort of more new innovation with the DSO
Absolutely.
structures, right? That are incredibly prevalent and that are sort of the rage, certainly across Pennsylvania, where I am, into Ohio, the Midwest, and if those are done properly, in my view, prosecutors still mostly don't like them. I think there's still a lot of skepticism about those approaches. There's skepticism that you really do still have, practice level controls occurring as opposed to sort of having everything rolled up under a corporate structure. But it's a line drawing exercise, and there are some very sophisticated organizations out there that have smart lawyers, amongst other things, that put together contracts that take into account all the kinds of things that Eric was talking about before, right? That have opinion letters put in place in advance, that have distinctions between what decisions need to be sort of happening at the actual brick and mortar office level, versus what types of services can be provided, back office or otherwise, from the corporate infrastructure. The things that I was always interested in when I was looking at that kind of a stuff from an investigative standpoint, which I'm still interested in when I'm doing an internal investigation or where I represent somebody, what are the communications back and forth between the brick and mortar offices and the sort of corporate MSO, DSO, right? What are the metrics that the corporate entity are tracking on a weekly, daily, or monthly basis? What are the metrics that are not being tracked, for that matter, on a, daily, weekly, monthly basis? What are the changes in behavior at the, actual practice of medicine perspective that you see post-acquisition, post sort of MSA relationship? And, do those all inure from a profit standpoint to the benefit of, sort of the new corporate partner, we'll kind of say, right? And then, is there any compliance infrastructure that is built out at the time that this relationship is being put together? And, too often, unfortunately, the answer to that last question is, none or minimal.
Those are great points. So that's going to lead me to, I want to do some Q&A with Eric and you. So Eric, I want to throw this first question over to you. What what would be, in your mind, some of the pre-investment due diligence that these PE firms need to be thinking about, rather than just looking at this from a dollar and cents profitability standpoint? What would be your recommendation for some of the due diligence pre-investment?
So the real life example, we had a project over where I am a couple of years ago where a private equity company was looking to come in and buy a small chain of optometry stores. It was a chain, I think it was 7 or 8 locations, and they did some medical optometry. And so, they wanted, as part of their due diligence, they wanted, us to go in and do a few audits. And I had said that it was important to do an audit of each one of the locations. Now, we didn't have to go crazy with statistical sampling, but at least a way to cross the T and dot the I was, if it was 7 locations, let's look at 30 or 40 records from each location. Because my fear was that, in the aggregate, they were looking at what the company, as a 7 location in a box, what they made. And I brought up to them, I said, but the part that you're missing is, do you have a location that's a loss leader? And do you have one that's inordinately profitable? And are they keeping the loss leader for some sort of tax benefit, right? So is it worth keeping a place that's losing $100,000 a year to offset the costs of a place that's making $400,000 or $500,000 a year? And I just think, outside of a fraud, waste, abuse, compliance perspective, you just want to know those things, right? Because maybe at the end of the day, you want to buy that chain, but you want to close that loss leader, or maybe you don't buy it. Maybe you buy the chain, but that's not part of your equation. So, just some of your basic due diligence is going to be taking a look. If you've got, obviously, the more locations that you've got, or the larger the practice, the more that you have to get a little bit more invasive. But to not do at least some sort of probe review of each one of the locations, or at least take a look individually and say, okay, why is this place losing $100,000? But this place is making $400,000 or $500,000 in profit? You got to think about that. That's number one. Number two, I think the place where people really miss the mark is the realization and understanding that the OIG has opined for years that the use of 1099 sales reps could have an effect on violation of AKS, or the anti-kickback statute. And I think that the problem there is that a lot of these smaller groups that don't have the ability to hire someone as a W-2 or a full-time person, they rely on these 1099ers. And, really, when you look at that relative to some of the opinions that are out there from OIG, they fall back on the IRS's bona fide employment requirement. And so, are these people really employees or not? And I think that there's a huge lapse in that. And you can really go and look at different state laws and see, you have someone that comes in as a 1099. For example, New York State, that is a super liberal state when it comes to a definition of an employee. Essentially, if you look at what the rule in New York State is, unless you're hiring the plumber to come in and point to the leaky faucet, that person, when they walk in the door, is going to be considered an employee, because you've got to be able to demonstrate that the person that's doing work for you takes zero instruction from you on how to do the job, when to do the job, and where to do the job. And so the plumbing one is a great example, because the plumber shows up at your house, you point to the leaky toilet and say, fix it. You don't give him direction on how to do it and the manner in which to do it. So I think that the two big areas for me that are huge concerns are, what is causing someone to be a loss leader, or why is another location inordinately profitable? And then the other piece is, are you bringing people in as W-2s, or are they 1099s? And what are the potential implications of bringing someone in as a W-2 or 1099? And in that same vein, the last piece, and I actually do a ton of presentations about this, is open payments, the Sunshine Act. There are a whole bunch of cases out there in which AKS was violated as a result of OIG agents, looking at one thing and then just going on to the open payments website and saying, why are you paying, why is there a line item for gifts and gratuities? What gift or gratuity are you giving to a doctor in return for using your product, or what sort of royalty agreement do you have? So those are the big ones, and they all will fall back into that sort of potential kickback scenario.
So there was a big case a couple of years back, which was United States Etrilayer, Medrano, and Lopez v. Diabetic Care RX, which was doing business as Patient Care America, and they were a compounding facility. And this organization, this company, was part of a portfolio for a private investment firm, private equity firm, excuse me. And they wound up settling for $21 million based on claims submitted by, this portfolio company. And one of the things that, Colin, I wanted to talk about, because obviously the PE company itself and its partners were functioning as directors, executives of these portfolio companies. And, as part of that, the organizations have to think about their level of involvement in day-to-day operations and business decisions. Otherwise, they find themselves getting dragged into the middle of an FCA. So as an attorney, because I know that, and I don't want you to approach this from a former prosecutor standpoint. I want you to think about this now as a defense attorney, advising your clients, because we all know that, they come to you for advice, but a lot of times they don't follow it because it may not be financially, beneficial to them. What guidance, what advice would you give to PE firms with regard to their involvement in day-to-day operations and business decisions?
Well, I think you just put your finger on the key question in and around all of this stuff, right? And it's a really timely question, because I think the proper advice to give has changed over the last 5 or 6 years, right? And so, the decision you just referenced, or the settlement you just referenced, I think that was a Southern Florida case, if I remember correctly. That was sort of how I think most of us thought about the dividing lines for private equity potential liability and False Claims Act cases for a long time, which was essentially, what's the degree of active control and sort of direct involvement in the underlying sort of business. There, if I'm remembering correctly, the distinction at the motion to dismiss stage was, yes, there's enough control here for the private equity folks on the marketing scheme and the AKS stuff. And then I think it settles after the motion to dismiss decision is done, but there wasn't on some ancillary allegations about copays and maybe something else. I don't remember. And so it was more of a sort of fact specific inquiry, even though it was at the motion to dismiss stage, looking at allegations, right? The thing is, in some of the more recent decisions that we're seeing come out, DOJ is getting more aggressive in sort of approaching where that dividing line is. And we've got new case law out there from a causation standpoint, and, in terms of what it means to sort of cause a claim to be submitted, that suggests to me, at least, if we're giving good advice to clients, if you're in the PE business and you're investing, and if you're doing anything other than being a truly passive investor, which isn't really the idea of private equity in the first place, right? I mean, the whole idea is that you're identifying an undervalued asset that your management acumen is going to actually, in addition to your capital, is going to sort of supercharge from a revenue perspective, right? And so unless you're talking about purely passive investments, you're buying a significant amount of risk the moment that you are getting any kind of reports up the chain, right? The moment that you have at least a board member, sort of sitting, on the portfolio company. So, you're right. People aren't going to always follow the advice, but to me, the wisdom of the last 5 or 6 years is that it is increasingly difficult to sort of take the perspective that we weren't involved enough, that you aren't, potentially buying yourself liability. And at that point, in my view, it's much smarter to just sort of in for a penny, in for a pound, we're going to embrace the idea that a real compliance program and real due diligence efforts are part of the cost of business of making these investments in the first place.
So you raised a great point, Eric. I'm going to come to you in just a moment. So between 2015 and 2019, there was a 50% increase in private equity engagement, right? So deals, right, that were prior to 2015, just under $40 billion, had grown to just under $80 billion between 2015 and 2019. But what's even more interesting, and to your point, Colin, is that, as an investor, you're looking for these undervalued assets to be able to grow them. So between 2019 and 2020, PE during the pandemic grew by 21%. That's a staggering percentage, 21% in 1 year between 2019 and 2020. So, Eric, my question goes to you with regard to ongoing compliance activities, right? So, I'm the compliance guy, but you're my subject matter expert today, right? And as a retired OIG investigator, and I know you worked on a lot of corporate integrity agreements, structuring those, engaging with the DOJ to make recommendations on, whether you thought it was criminal or whether it was strict civil or liability, whatever it is. From an ongoing compliance activity standpoint, what do you recommend for PE firms acquiring healthcare organizations to do to mitigate their risks as much as possible?
Yeah, that's a great question. I mean, look, the first issue is that when you're a PE company, are you apples to apples? Meaning, are you a private equity company that deals primarily in the healthcare sector? Because sometimes it's not about the undervaluation. Sometimes it's about, well, we've already got these companies in our portfolio. By adding these companies, we're going to be able to grow that business, right? It may not be that it's underperforming, but it may be, hey, look, are you a company that does this piece of the puzzle, and we need someone that does this piece, and when we put these two together, it becomes exponentially greater. So I think, first, just to kind of back up a little bit, the 21% increase from 2019 to 2020, I think part of that is that we've got all of this technology that's kind of exploding, right? And okay, COVID came, but there was this huge explosion of technology that was coming into fruition. And look, what we're seeing now is that a lot of that is now literally blowing up, right? It exploded and now it's blowing up, right? And, two different connotations. And that's the result of the fact that, people were coming in and maybe they were overvaluating the business and it's not, to what it is. But I think from a compliance and an ongoing compliance perspective, it's making sure that the people that are in the positions of running the show, whether it be your compliance person. By the way, do you know that there's someone called the compliance gal or the compliance lady? I don't know if you knew that, but you've clearly got competition. I think she has actually a full head of hair. So you start with the basic and then you go up. But
so just so you know, in the day and age that we're in right now, I actually had to trademark compliance person so I could cover myself. So if anybody's out there using the compliance person,
thank God,
you get a cease and desist.
Yeah. So I think that, part of it is that if you're bringing in this money and you're creating a board and you're putting people in charge, you still got to have the right people in the position to understand the nuances. Someone who's spent their career in IT, PE may know IT and infrastructure and technology, but doesn't know a thing about healthcare. And to kind of get to the first thing that Colin said is, in the world of business, it's okay to pay referral fees in just about every sector of the American economy, with the exception of federal healthcare programs. And now it's really becoming a problem in the commercial healthcare because you not only have the state laws, but, and you and I, Sean, we talk about this all the time. it's the transference of state law under the federal umbrella with the Travel Act. And as you know, I worked on one of the first cases involving the Travel Act in the District of New Jersey. And, you're seeing that now come to fruition. So there's this greater microscope on the relationships that exist that in every other sector of American business, people don't really even bat an eye over. And so I think the biggest thing from a compliance perspective to me are the people that are there, helping to shape the direction, the people that are the right people. I always say in the compliance world, in a world of no, compliance people are more no. And I say it all the time with things. In the fraud, waste, abuse, compliance world, I say, no, like you're not doing that. Let's vet this first and then come up with a yes. It's not this, I have this great idea. It should be, we have an idea and we'd like to vet this out versus we have this great idea and this is what we're going to do. And I think that, that's where a little bit of the pickle is going to come in, because the False Claims Act is so broad. And then you get into the world of the civil monetary penalties, which is even more broad, right? Very heavily favored in the government. Some of the rules are very charged positively towards the government. And so the biggest issue is finding the right people to help to guide, shape, and direct opinions that are where they want to go from that business perspective.
I think that's sound advice. So I want to build on something, Colin. I want to go to you on this one. So I think we all recognize that, in our industry where the risk of FCA liability is so significant, it's critical that private equity firms establish a culture of compliance, right? It's not just a culture of compliance for the healthcare organization, right? Because if you are the owner of these portfolio companies, right, you have a legal, ethical, fiduciary responsibility to establish that culture of compliance that extends into these portfolio companies to ensure anti-fraud, activities, to ensure, proper training. But where I'm going with this is boards of directors. Okay. So I have a lot of board of directors that, somebody will reach out to me and they'll say, what is our exposure? What is our liability? And why should we have to engage in this training and education if we're not part of the daily, business decisions? And I try to explain to them that as the board of directors, you're driving the direction of the organization. And as a matter of fact, there was actually guidance put out under the Yates memo back in 2015 that specifically targets board members, because it doesn't, and correct me if I'm wrong, doesn't the Yates memo actually talk about corporate misbehavior? And they identify that corporations can't misbehave. It's the people in charge that actually misbehave. So my question to you is, what liability, and is it absolute liability, that board of director members face if their portfolio companies, are engaged in nefarious activities?
It's an interesting decision. I mean, I think, an interesting question. I mean, if you're a board member, you obviously have a whole host of responsibilities, like you were sort of saying. And, that's not a gig where you just sort of, you take it and then you do nothing. You don't educate yourself if you don't walk in with the proper sort of set of knowledge, or you stick your head in the sand, with respect to, what your obligations are. And so, like anything else where you do have those kinds of obligations, where you are privy to one degree of information or another, and a lot of that's going to be fact dependent, right? Then, of course you could have, the potential exposure, under a fiduciary, duties sort of perspective. There are extremes where you could have criminal exposure, depending upon sort of exactly what kind of a situation that we're talking about. We're somewhere in between. But I think, the larger point, which I think is really what you're kind of getting at here, Sean, right, is that if there was ever a day where folks that are involved from a private equity standpoint, could feel free, could feel comfortable with the idea that we've got enough of a buffer between us and the active management. Put aside the specifics of exactly who's sitting on the board. Put aside, the exact specifics of just sort of how much interfacing we have. Hey, there's enough of a buffer here that we don't need to worry about the PE company itself, let alone any individuals employed by or owning the PE company facing liability. Those days are over, right? And so if you're sitting on a board for every reason imaginable at this point, you need to be thinking about the things that the portfolio companies have always been appropriately thinking about, right? Which is, do we have the kind of compliance program in place that HHS and DOJ has guidance out there that says we're supposed to have, right? To your point, and DOJ talks about this incessantly, is there a compliance program out there that not just checks the box on the things that you can pull off the internet and pretend you have a compliance program, but is it generally situated such that it does create that culture of compliance? And, that's not a static thing either, right? So if you're it's not enough to have a hotline, you got to actually process hotline complaints and then document what you do in response to them, right? As the law changes, what are you doing to educate people on the ground, et cetera? And so, is an individual board member going to be in charge of all those things? No, but is it a reasonable expectation to think, is the board paying attention to whether or not there is somebody that is the compliance officer? And is that more than just a title on an org chart? And, do they have a general sense and reason to believe that appropriate efforts are being made in that field? And if they don't, they can't just stick their head in the sand.
So, Eric, I have a couple of final questions that I want to pose to both of you guys. So, Eric, this will be the final question that I want to pose to you. So, taking into account and thinking about everything that Colin was just saying, would it make sense for the board of directors to create a subcommittee to evaluate policies and procedures and to advise the board on, proper language, ratification, all those kind of things when it comes to, taking bona fide steps to create a living, breathing program within that organization? Would you be a proponent of creating a subcommittee to the board of directors so that the board of directors isn't having to, read every single sentence in a policy or a procedure, right, which we know they're not going to want to do?
Right. Well, you and Colin actually just hit the nail on the head with a couple of things. The most important being that the compliance policy is one that you can independently be able to demonstrate actually is doing things. And then secondly, that it's a living document, meaning that, is there a history of revision and review with any of those policies? I mean, that's just sort of the standard that as the law changes, as technology changes, your policies today can't necessarily be your policies of tomorrow, right? You have to be able to look at them. And, the example that Colin gave, which is a really good one, is that you've got a hotline and, okay, you've checked the box, the OIG's compliance guidance says you should have a hotline, and have, the ability to vet these out. Okay, I have a hotline, but, am I checking it on a daily basis? Is there a log that's being kept that you're maintaining? I got this complaint, it's anonymous. We vetted it. Is there something that when the OIG comes knocking, right, you can't bulletproof yourself, but you certainly want to be in a position to say, holy cow, we had 20 complaints last year and we vetted them and found that none of the 20 were warranted. And here are the steps we took to vet them out, versus just having a piece of paper that says, yes, you can call, 1-800, pharmacy fraud. That's our anonymous tip line, or, whatever it may be. So you then take that and you parlay it into sort of a subcommittee, which are people that are just reporting to the board on the findings of whatever it is that the task is, where ultimately the board isn't making direct providing direct guidance, right? So they're ingesting information and then making more corporate decisions like, hey, you guys have this policy and you have a subcommittee that's supposed to review it, and your subcommittee person isn't reviewing it. So as the board, we're saying, hey, new person is in charge, right? Making these sort of more blanket corporate decisions versus getting their hands in the weeds and saying, hey, you had these 20 complaints and we want to know about these 5. And no, we want you to look at these versus those. And I think that's where some of that problem language comes into play, is when you've got a board that's providing a veiled firewall, but they're really providing that granular level of direction. So, they're not supposed to be doing that. And that's where you get, I think, that problem. And I think having, whether it be a subcommittee or just some buffer layer where you've got somebody who's reporting on what's being done and to track that, and to be able to show that decisions that are being made on the day-to-day are decisions that are being made outside of the senior leadership of whoever it is that's ultimately, writing that check.
Great points. Colin, final question that I want to throw to you. I am not a big fan of putting a lot of stuff into emails. I'm not a fan of putting a lot of stuff into writing unless the attorneys are saying, no, I've got to have that in writing, Sean. So I want to talk about something called use of language, right? I think that's the more legal term, the more technical term for it. And we're talking about communications. What guidance would you give to those in PE firms communicating with their portfolio companies when it comes to what should and what should not be put into, a communication, and when should counsel be copied on those to put in place privilege? But keeping in mind, just simply CCing an attorney on an email doesn't extend the attorney-client privilege. There has to be an engagement between that attorney and the parties to that communication in order for it to be privileged. Am I correct on that? And then can you give us your thoughts?
Sure. Yeah. And, when I think about, use of language, and the way that you communicate, I always think back to a law firm that I worked at as a young lawyer, when I was living in DC, where every time the screen would pop up for the computer, the managing partner felt very strongly about this. Before you could sign in, you get a message that says dangerous communication device. Right. And the idea, which I've always just kind of loved. Right. And the idea was to try and remind people, you need to be thoughtful and purposeful when you're logging into your email and you're blasting out messages. And everybody fails in that regard periodically, but some fail more than others. Right. Anybody that has, and God knows I've done this too, been standing in line about to get onto an airplane and you're firing off one last email and you're really not being as purposeful as you should be in trying to articulate whatever that message is, whether it's to a client or somebody else. Or I'm responding to an email because I have insomnia and it's 1:30 in the morning. And by the way, really, I should have waited until I got up at 6:30 to send that email, right? And it's not because I'm putting anything in it that's, bad or the like, but it's not a purposeful, efficient communication. And when we're not being purposeful and we're not being, thoughtful, years later, that's when you get emails and text messages and the like that can be potentially ripped out of context and, used against you in ways that can be incredibly damaging, right? I mean, I would say if you get to a criminal trial, my estimate is there's always a banker's box or two of documents that really matter. In the modern world, you got to go through terabytes of data to find the 2 boxes of documents now, but for time immemorial, it's been 2 banker's boxes of documents that really matter. And a non-de minimis number of those are stupid emails that don't actually mean what people intended them to mean. and where if they would have been more thoughtful, they never would have happened. So how do you get around that, right? And I tend to agree with you, Sean, for a lot of reasons. And I'm just old, so this is how I think about it. If you can talk about something in person, that's just a better way to communicate. All right, well, we can't always meet in person. Fine. If you can talk about something on the telephone, that's a more efficient way of communicating than an email is. And not because you're trying to hide anything, because there's give and take. And people understand nonverbal cues, and they can interrupt you if they don't understand what you're saying, and then you can clarify things, right? And so to me, and then I guess email is better than texts, and texts should not exist because they're the worst thing in the world, right? So
absolutely.
And that's why prosecutors love text messages. So, it's hard though to convince clients about any of those things because it's so much easier to send an email to 9 people than it is to have a meeting. And the management gurus every 5 years decide that meetings are good or bad, and they switch back and forth. It's a little bit like whether eggs are good for you, right? And so, I think that is something that I hammer home all the time when I talk to people, but I don't feel like I'm winning the battle. You guys might be doing better than me. On the privilege thing, I generally get 2 reactions from clients. It's either, why would I want to copy a lawyer on anything? Lawyers are evil and cost me money. So they just don't want to involve the lawyer at all. Or I copy the lawyer at everything, ergo nothing is ever discoverable, right? And meanwhile, the lawyer is on the CC line and never has responded to an email, never has provided any advice in response to the back and forth between people. Or my favorite, the lawyer is copied on a communication with somebody outside of the entity that you're trying to do a deal on. And then you say, yeah, but my lawyer was on it. And then you have to have a very unpleasant conversation with somebody, right? And so trying to explain to people, if information needs to be gathered that does relate to the provision of legal advice, then by all means, you should make that clear in the email, either by copying the lawyer, or you don't even have to, just embedding in the body of the email, at the request of counsel, blah, 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 right? The lawyer doesn't have to be on it to make it be privileged. But again, when you're trying to scale that stuff and educate people, I mean, the only way to do that, I think, is through regular trainings. And, that's often a difficult sell.
And that training goes back to, once again, making sure that you have a policy that is specific to your organization and that it's regularly reviewed, updated. To Colin's point, management every so often makes a decision as to whether this type of communication is still valid or not. And, in keeping your employees at the highest level of education is the way that you oftentimes minimize the opportunity for bad things to happen. All right. So this is going to bring us to the end of this compliance legal roundtable. I am so grateful for Eric Rubenstein of Advize Healthcare and Colin Callahan of Flannery Georgalis, law firm out of Pennsylvania, for taking time out of their busy schedules to hang out with me and to share their knowledge on private equity and how to mitigate risk with all of you. So, guys, any parting words before we sign off today? And then there was nothing. All right, that's going to wrap it up for this episode of The Compliance Guy. Thank you again for tuning in, logging on, and hanging out with us just for a little while. As always, remember, be good to yourself, but more importantly, y'all be good to each other. Take care.